Hello. I don't think I can really follow what Denise has just said. It's almost impossible to follow that. A really fantastically awful story, a bit like the stories we were hearing from Lee this morning. So I won't attempt to do anything like that, but the theme that our panel is going to want to cover follows on very well from the theme of the last one. We're really going to be discussing what good consumer focused regulation looks like, and we're going to be focusing absolutely on solutions, not just on the problems. But we're going to start with a short video, which is a bit me discussing with a very small group of regulators and consumer experts from a number of different sectors to share their learnings, because we're very keen on sharing from other sectors. So cameras roll. We in the legal services sector, as I think you know, have been exploring how to help regulators in our sector to become more consumer focused, and how to understand what consumer focused regulation really looks like, and how in particular they can learn from other sectors, because we've all got quite a lot to learn from each other. And I know that each of you have got sort of really some good stories to tell about things that you've done in your sector which have improved things, perhaps areas where you'd like to do a bit more. Helen, can I just start with you?
The example I think I would give is the consumer duty, whereby firms must act to deliver good outcomes for consumers. I mean, it's underpinned by some general principles around acting in good faith towards their retail customers, avoiding foreseeable harm for their customers, and enabling and supporting effective decision-making by consumers. And by that, I mean enabling them to pursue their financial objectives. The panel advocated very strongly for a board champion on the boards of firms that were implementing the consumer duty. The idea being that if the consumer duty was to succeed, there needed to be a really strong cultural change within these firms.
So that's really, really useful. Gillian, can I just come on to you? I know you're at Citizens Advice, you have a particular duty to represent the interests of energy consumers.
We really see the interconnectedness of people's problems, and that informs the advocacy solutions we put forward. A good example of this was the issue around the force fitting of prepayment meters, which captured a lot of press, politician and regulator attention last year. That was following the publication of a report from us in January, and then the Times investigation in February. It showed that prepayment meters were being installed in households where there was significant risk of disconnection. So we had been raising problems about this with Ofgem for many months before this. We first did a policy referral about 8-9 months earlier, when it became clear from the client contacts we were receiving that the existing consumer protection framework was starting to break down as a result of the cost of living crisis. So as a result, Ofgem did come through and put some additional protections in place, but I think they'd also admit that they didn't sufficiently heed the warnings that we had been giving them. And in terms of what good looks like in this space, I think you need regulators that are ready and committed to listening to the views of consumer advocates.
And it often takes a news story or something to make people listen, and a good regulator will listen quickly. The good news is that perhaps they're beginning to do that.
I would think so. I think they'd respond differently.
Mike, at Consumer Council for Water, you do an awful lot of dealing with complaints, consumer complaints.
Yeah, I mean, people come to us if they've exhausted the complaint process between themselves and the companies. And we've done a couple of things over the last 6 months to get ourselves closer to the customer and actually get even more insight from that process. So the first thing was that we've taken over the ADR contract. Before, from a customer point of view, you wouldn't resolve your complaint with your water company. You'd then come to us. We would sort of mediate and be the kind of working on behalf of customers to try and find a resolution. Then they could go to ADR. So there's all these steps in the process. Now we've taken that contract in-house, we're letting that contract. It means it's slick, it's seamless for the customers too. We get then extra insight from the ADR step that we weren't getting before. So that's really good. But the other thing we've done is we've reinvented our complaint assessments. Go into water companies and do a deep dive, send a team in, do a deep dive on complaints.
Do you dive into water issues?
You would dive into it. It's a swirling whirlpool of issues. But by doing that, you're not just being walked through a bunch of complaints that you pick at random. you learn so much more about the culture of the company. Now, you've talked about culture, Helen, from a boardroom level. Now, by doing the complaints assessment, you get to see culture at the grassroots level.
Yeah.
And for all this stuff to be effective, it's got to be throughout the depth of the organization. And going back to the regulatory side of this, we've been keeping off in the loop, you know, what we're hearing from this, because it is about getting that intel and then using it effectively to secure a change. Everyone wants to be a superhero and put their cape on and solve a problem once it's a big problem. It shouldn't be like that. We should be spotting the problems when they're small and preventing them from ballooning into the big consumer issues that are going to hit the news. But of course, that's less exciting for some people. But we need to change the mindset so that we're nipping things in the bud.
The example that I was going to use of an approach that we've taken within the aviation industry leads on beautifully from what Mike was just saying. So we've been looking particularly at innovation and new technologies, and in the aviation sector, in the jargon, AAM, advanced air mobility. So things like flying, taxis, and those sorts of things. But looking at it right from the start to make sure that consumers are built into all of the planning, because they don't exist yet. Actually making sure that as the regulation is developed, that the consumer principles are absolutely baked in right from the start. So we did really interesting piece of work with the team in the Civil Aviation Authority, in the Sandbox team, looking at we developed a sort of a toolkit for inventors and designers when they're talking to the CAA about their new technology and what they want to do, which lays out the consumer principles and the questions that they need to be asking themselves as they're developing their products and their services. Have they thought about how that people with particular issues would still be able to access the services? And thinking about it right from the beginning, because it's so much harder to retrofit that onto a service that's already been developed. When they're then shaping regulation for these new technologies and these new innovative approaches, the consumers are built right in from the very start.
Yes, this is very much consumer-focused regulation by
Totally.
design, from the earliest design stage.
Exactly.
Something that regulators traditionally haven't done very well, but it's a really good example to think about.
And another sort of follow-up to that is the register. You go to the register and you check authorization. The Financial Conduct Authority's register is heavily skewed really towards the financial services sector. So for a consumer to actually go and check whether the firm they're dealing with or the individual they're dealing with is authorized is very difficult, because it's full of technical jargon. There are various steps that you have to go through. It's not always clear. The panel have been working very closely with the FCA around a redesign of retrofitting, a redesign of the register to enable it to be more accessible to consumers. And sort of consumer testing is key.
I think there are two things in particular that I have taken away from this conversation, along with lots of other messages. The first is the need to be talking much more regularly with other sectors, and that should be the regulators as well as the consumer panels, in order to make sure that we're really learning from each other. And the other thing, which is quite a common theme, is about the need to get in very early when you're designing a policy. Get in early with your consumer principles, make sure it's done properly. So I think that's been a really useful couple of lessons. Right, well, Phil Meghna, panel, would you come and join me? And I think we've got somebody also coming in online who, with any luck, will appear with a very large face right behind me, if we're lucky. The word, what's it called? A word bomb? No, whatever it is. Yeah, those were the sort of words that were particularly mentioned in that video. So here we have our panel, and I'm sure Dan will be joining us in a minute. We're going to be taking the discussion that was started off there, we're taking it forward very much into how these lessons can be applied into different aspects in different sectors. So I'm looking forward to hearing some stories from each of you. Zoe, can we start with you? You have worked in consumer policy in a number of different sectors, not just one, there's quite a lot of different ones. From your observations, what would you say are the key things that both regulators and providers need to do in order to really home in on consumer needs? Hello, Dan, by the way. There's Dan.
I think the most important thing is really strong consumer-centric leadership, in particular the individuals at chair and chief exec level, because they're so important in terms of setting the not just the priorities of the organisation, but the tone and the culture of the organisation. So, and I think the factors that make a really good consumer-centric regulator are also the same factors that make a really good consumer-centric company as well. So, for example, in the energy sector, there's a company called UK Power Networks. They've got a chief exec that very regularly brings in consumer groups, and we have a really robust discussion. And I think by doing that, it gives us confidence as civil society voices that this company is taking our issues seriously. But it also sends a clear message to the company as well that consumer issues matter. One of the speakers in the video, Helen, talked about having a consumer champion at a board level. There is real value in that, having somebody who can bring a consumer lens to decision making, that can make sure that the kind of, I call it the Daily Mail test, is applied to decisions to check that they're going to be seen as fair from the public's point of view. But I don't think that a single consumer advocate is enough, and I've been the lone consumer voice, the lone consumer champion on a board, and it's not a particularly great place to be. And I think there's also a risk in that instance that it's seen as the responsibility of the individual, when really what you want to do is to embed a culture where everybody is thinking about the consumers, particularly customers in more vulnerable situations, so they all own that. I think in the kind of strongest regulators, they set a really high bar in terms of expectations. They know as well how to use soft power, and this has come up a number of times today about regulators using their voice, in particular using their voice towards government as well. And I think there's lots of opportunities to do that at the moment, it seems, from the discussions we've had this morning. So, for example, during COVID, a number of the chief execs also set an expectation for water companies, for energy companies, that they didn't expect customers to be disconnected, or they expected them to be treated fairly. If they were struggling, that they should do more to help customers in need. I think the kind of two other areas that I'll stress now, and I'm sure we'll come on to other things, is the importance. I think good regulators who are consumer centric, they know their providers. And Mike Heel on the video talked about understanding the culture of the providers. They know their providers, they also know their consumers, the diversity of their needs, and they understand their experiences from the lived experience side. And they have mechanisms in place to capture the consumer experiences on an ongoing basis, so you can see trends over time. They also know who their stakeholders are. A number of regulators are engaging with the same people over and over, and they think they're doing it terribly well, but actually there's hundreds of groups that they should be engaging with that they're not actually reaching. And then with the engagement processes, I think the best regulators, they're engaging with the right people at the right time in the right way. And I've been worked with too many regulators that put documents out to consultation. They say, oh, it's amazing, we've got 100 responses to this, isn't it wonderful? But actually, when you look at the representativeness of those responses, there are really key fundamental voices that just aren't being heard in that decision making. And never have I heard a regulator go, oh, actually, we're not going to take this decision because we don't think we've heard from the right people. And I think that needs to be something we think about more. And then with horizon scanning, the Aviation Authority, I was really interested to hear about what they're doing in terms of future thinking. I think it's really important that regulators are ahead of the game in terms of not just policy and social change and technological change, but they really think about how that needs to influence their decision making in the future. And I think, if nothing else, the most important thing of all is about being proactive and taking early action. Gillian Cooper there on Citizens Advice was kind of very gracious, saying that raised the issue for a number of months with the regulators about force fitting of prepayment meters. I was working for Ofgem 2016. We knew about that issue then. I mean, the issues of poor treatment of customers in debt been going on, and prepayment meter customers have been going on for more than 2 decades. And I think if we really want to reshape all regulation, it's about proactive regulation, anticipating problems and nipping them in the bud. And that's, I think, the most important thing.
Thanks very much. Loads of issues there that we might follow up on afterwards if we get time, but I need to pass on to Meghna, who is going to say a bit more about the energy sector. We're hearing quite a lot about the energy sector today. I'm not sure that's very surprising because of the number of challenges that have been faced for consumers there. And I think you had some specific things you wanted to tell us about how the sector has met or has not met the needs of vulnerable customers.
Yeah, thanks. I hope everyone can hear me. Great. So I think a couple of things I'd say there is, if it was about 10 years ago, then certainly things would have sounded quite different then, because we were a regulator that was just beginning to look at vulnerability as a concept. So our primary duty is about protecting consumers in the present and in the future. So in terms of sort of what are we there to do, we are quite clearly set out in that way. But we've been on a really interesting journey in sort of unpacking that in terms of what does that mean for an energy consumer. And you'll see a lot in my sector being spoken about in terms of fairness. And so I think one of the best things that we did was really sort of convert that primary duty into something that was a more accessible definition of vulnerability. We recognize that this is not just about being having sort of personal characteristics that make you vulnerable, but it's also the behavior of the market that could make it worse for you. So it was really sort of that strategic vision, which was sort of came about around 2014, 2015 time, that really sort of started us on a journey. And being a regulator is a real privilege, and you really have to approach it with humility. You really can't, and we certainly don't approach our role thinking we have a monopoly over all the good ideas. So there's something there about partnerships, as others have spoken earlier. And certainly when I took on that area, I remember we only used to speak to citizens' advice, nobody else. And then soon we sort of started this program of work where we spoke to charities that were working in Wales, charities that were working in Scotland, and it sort of created a real richness of debate. So again, you see there's an element of, you set the strategic vision, you get to the point of how are you collecting that insight. So you start operationalizing that vision into something that's more sort of real for people. And that's where I think things like consumer research and insights, I think the SRA's presentation previously and the work that the SLB is doing is fantastic, because it really helps you get into what is the perception about the market and what's the gap in that perception as well. And that's a regulatory responsibility as well, because you hear a lot of views, but it's really for the regulator to step in and say, all right, we've listened to all of these views, we've brought people around the table, and this is where we're going to take our priorities. And that's not an easy job. And I know people in this room know that quite well. The second bit is, as a regulator, one of the most important things I think we've done in recent years, and we've really been tested, by the way, there's the COVID pandemic, which impacted all sectors. And then we came to a stage of the geopolitical reasons causing an energy crisis that was unprecedented. And so we were, as a regulator, really in that tension of the cost of living, the cost of your energy, that could really be sometimes be a horrible choice between living and heating, and then the market resilience and stability. So as an economic regulator, it's the stuff I learned in university, and I hope never to be sort of viewing in real life, but that's where we were. So there's a question about how do you navigate a market that's going through a lot of change, and the pace of that change is going to hit you. And in all of that plays the consumer at the center of your regulation. And this is where I think embracing technology, embracing consumer insights, partnerships really helped us. And the way we did it, as in how did we bring it to life, was create a common consumer outcomes framework. Whether you're in water, or you're in energy, or you're in the legal sector. I'm not an expert of the legal sector, but I'd say it comes down to, are you paying a fair price for your service? Have you got great service from your provider? Do you know where to go when you need the help? And do you trust the market? Those are sort of fundamental things across all regulators. So the customer outcomes framework really tried to tie it into something that an average customer can easily engage with. And I think it's really that that thing about converting a vision into more sort of tangible things that really sort of helped us sort of really deal with a very, very difficult time for the
Yeah,
sector.
I've certainly seen the journey of energy regulation. Right, we're now going to move on to Dan, who is sitting in Cardiff, can't be with us today, unfortunately. Dan is a colleague of mine on the Legal Services Consumer Panel. He's also a very distinguished academic specialising in access to justice, which is jolly fortunate, because I would want to ask you, Dan, how do you think that really good consumer-focused regulation can play a part in increasing access to justice? For many years, people thought that these things were completely separate, but I don't think they have to be. And I wondered if you could help us with that question.
Yeah, thanks, Sarah. Hi, everyone. So, yeah, I was told we've got 4 minutes and you've all got a clock on stage. Very strict 4 minutes. And the thing that keeps going around my head is there's a Madonna song called "We've Only Got 4 Minutes to Save the World." And 4 minutes ain't really enough time to save the world. And it's not enough time to save the justice system either, because there's lots and lots of problems, some of which we've heard about on that really important panel just before us right now. I was thinking, what can I talk about in 4 minutes about access to justice that isn't just listing a load of problems and then having a wee cry at the end? And one thing I thought about was the potential solution that often comes up in these debates and these discussions. So I'm going to talk to that. A lot of folk are quite hopeful about technology. Some are optimistic. Some even see it as a panacea for access to justice. And it ain't a panacea. You can't use technology to fix a chronically underfunded advice sector. But there is some potential in technology for access to justice, and it can be used to help empower consumers. So it's an area in which regulators can play a role. And I've done a few projects over the last couple of years looking at technology in the advice sector in particular. So I've been working with social welfare organizations as they use technology. And the advice sector is always very innovative. They have to be pragmatic. They have to be very much flexible because of the constraints they work under. And that was shown during the pandemic when they transitioned very successfully from a face-to-face service to an entirely remote service. And then it was shown again during that same pandemic when they transitioned successfully from a fully remote service to a service that combined remote and face-to-face provisions in various different ways, what we call hybrid advice, sometimes blended delivery. And that blended delivery does have potential for access to justice. So for organizations, it can help them to engage clients. It can broaden the reach to different client groups. And there are some potential efficiency savings there. For example, if some clients are suitable to be diverted to a chatbot or to a self-help guide, it can free up resource that can be used to meet with other clients. And this point was made in the last panel as well. There's no one-size-fits-all approach to this kind of stuff. And invariably, organizations have to triage their clients to see what particular methods are suitable for each individual on a case-by-case basis. Broadly, though, one of the things we've seen is that some client groups can be quite receptive to technology. Some folk living in rural areas, some people with mobility-related disabilities, often younger client groups are quite enthusiastic about the use of technology. And this point was made in that SRA presentation in the last panel, there's always going to be a need for face-to-face advice. Yeah, there's going to be some folk for whom technology is inappropriate as a means of advice giving. That could be because of digital literacy issues. It could be because they simply don't have access to technology like a telephone. Some folk have learning disabilities, neurodivergence, mental health problems that make it inappropriate to conduct things remotely. But fundamentally, even people who are enthusiastic and can use technology value some sort of face-to-face provision. The social relationship is really important in advice giving. It helps to build up rapport. It helps to build up trust. So whatever accessibility or flexibility it gives to clients, clients always value having that face-to-face. So I think technology is something we probably will talk about at some point during this panel. So I wanted to raise it, but I wanted to raise a very important issue. I assume I'm probably at about 4 minutes, so I do tend to drone on sometimes.
Got about 20 seconds.
Technology. How many seconds?
20.
20, oh my gosh, 20 seconds, amazing. Yeah, technology can be really useful. We can't rely on it as a sole means of communication, because it will exclude people and it will add to inequality. So I think it's worth talking about that today. And the fundamental point under all of that, of course, is that whatever use of face-to-face and remote methods we have, there needs to be a properly funded sector with properly funded advisors to actually do their jobs.
Oh,
I
right.
reckon that's 20 seconds bang on.
Yeah,
Sarah.
well, a bit and a bit, yes. Yeah, no, well,
Oh.
there's a problem more than a solution. So I'm going to turn to Allan now and actually ask you quite a similar question, but you'll probably have a slightly different perspective. I sense a bit of an echo. Anyway, never mind. Now, I think your law centres help about 7,000 people every year with legal issues. So I'm sure you've got loads of really specific ideas on how to improve access to justice. But if you could focus particularly on areas that you think regulators might be able to help you with, that would be really useful.
Thank you. Yeah, you're right. We've got 38 full-time staff, mainly solicitors and caseworkers. We also have 400 pro bono help assistants as well, lawyers who help us, and we manage that. We operate in 3 locations in southwest London. I think the first thing is to identify the key issues. The key issue, I'm talking nationally now, not just locally in my area, is to identify the need and quantify it in terms of legal need. There are large regions that are desert areas of legal provision in social welfare law, huge areas. We've just done a survey in Surrey, funded by the county council, and we've identified there that there was no legal aid providers in the whole of Surrey for immigration and asylum benefits, community care, education, and just one housing legal aid provider. So we've put in an immigration caseworker funded by the county council now, working for clients in refuges across Surrey, and we're looking to put in more, and we're working with other agencies to try to fill that gap. But Surrey is just one example of a legal aid desert. Bristol Law Centre, I know, is moving more into the southwest area, which is also a legal aid desert. It's also a concern that was raised by this highly critical National Audit Office report, just published February 2024. It concluded, without a more proactive approach, the Ministry of Justice cannot guarantee access to justice for those eligible for help. So that's the first problem. The second problem is, even if we identify the need and we want to fill it, we've got to find some appropriately qualified legal caseworkers. We need lawyers with skills in social welfare law. Now, we're very grateful to our 400 pro bono staff, but even they struggle in some of the areas of complexity that immigration and housing throws up. So we have to put supervision in to make sure they're giving right advice. So we need lawyers with skills in social welfare law. And quite frankly, the legal profession and the law schools are not delivering. I accept a big factor for us is poor salaries, but I can't see that changing, quite frankly, in terms of attracting people into a law centre. So what can the regulator do? I have 2 proposals. The first one is, I think we do need to quantify the need more carefully in the regions. I would suggest establishing regional legal services boards in the desert areas, tasked to identify the gaps in social welfare law provision and to identify potential solutions, which will vary from region to region. Second thing we need to do is to tackle this skill shortage. There's no point in identifying the need if we haven't got anybody to fill it. We need innovation to foster the development of a stream of relevantly qualified lawyers, if only for a few years of their careers. Some sort of secondment, we need something, some sort of service that they put in. I encourage the Legal Services Board, the Law Society, Bar Council, university law schools to acknowledge this problem and together develop solutions to remedy the shortage of skilled lawyers that match our clients' needs. So to summarize, how do we empower vulnerable individuals or families to confront some of the most basic problems that they encounter, affecting their liberty, their housing, money, education, their care? Well, we can help by delivering appropriately qualified legal services that people need, where they need it.
I think that's brilliant. You've provided some practical, if not necessarily easy, but practical potential solutions to access to justice problems which regulators can have some place in dealing with. And I think that's really important, because for a long time we were in denial that this was a regulatory issue, and it isn't. I'm about to come to the audience for some questions, so please start thinking about the questions you want to ask. I just wanted one quick question to Dan. He's both behind and in front of me. This is wonderful. Are there any particular lessons that we can learn from things that have happened in Wales? I don't know if there are many people from Wales in the audience today, but you've got particular experience there. Anything that, that those of us who are working and supervising things in England can learn from your experience in Wales?
Yeah, thanks. Well, you certainly got one person from Wales. So you've got the manager of our North Wales Law Centre that I'm on the steering group for. Catherine is there. She could give you some great insight. Yeah, so the Welsh Government does do things differently. And I can talk about some of the positive things they do. I'm not going to evangelise. We don't have a great situation for the advice sector in Wales. We have deserts, which are worse than in most areas of England across social welfare law. We have real problems in criminal justice as well with the age of duty solicitors, for example. So we've got some really bad issues here. But the Welsh Government does do things differently. And when I talk to organisations in both countries, as I do in the various books that I write and the research that I do, there's often a sense that people in England would like some of the innovations that are in Wales to be followed. So the Welsh Government approach is specifically rooted in social justice. It's premised on the idea of taking a holistic view of society and trying to root out social inequality. You can see that in various levels. We've got the Wellbeing of Future Generations Act. We've implemented the socio-economic duty from the Equality Act. We actually have a social justice minister. But one of the key ways it comes out is that the Welsh Government has always shown a real keenness to work with the sector, to listen to them. So we have the National Advice Network, for example, which provides organisations working in the sector a direct link to influence Welsh Government policy.
I think we probably ought to move on to the audience, but can I just ask the civil servants who are here today to take a note of all those things that Dan have just said and take them back to your department? Thank you very much, Dan. I really need some questions, so please put up your hands. I'm told I'm not allowed to identify your gender in case I get it wrong, but there's a person in pink in the fourth row.
Hi, me again, Ginny Can. I just wondered if Allan had heard of the SWSQF, a group of city firms, getting on for about 20 or 30 now, getting together to fund social welfare lawyers in getting their SQEs 1 and 2. And also they then guarantee to do so many years work, I forget exactly how long, in that area of law, and they get a certain amount of tuition in particular things that they need to know about, as well as the basic. And that was an initiative put together by the City of London Law Society, entirely, and you know, sort of entirely their own initiative. And I think they've got, I don't know, something like, I forget how that's about, is it 500,000 now?
That's quite a lot, isn't it?
Yeah,
Yes.
maybe even more, actually. I may be undervaluing what they've
I've heard
done.
about that initiative, and I'd love to hear how it's going.
Yeah, I think it's great. It's a great initiative. I agree. I think the issue is that nationally, if you look at the national picture, there's a huge shortage of lawyers in social welfare law.
Yeah,
I think that's a great initiative, and I go to a lot of city law firms and talk to them and talk to their students. your article clerks coming through, trying to get them to work in welfare law. The only problem is, of course, is they tend not to stick into because their progression within the firm tends to be into the higher end value stuff. So they tend not to stick in the social welfare law areas.
I may be wrong about this because I haven't been involved in detail, but my understanding was that in fact they're not chosen from city law firms. They're chosen from people, promising people who are already working in law centres and places like that.
Yeah.
Who are committed but can't afford to pass the exams required to be a fully qualified solicitor. So they are not actually, by and large, I may be wrong, maybe there are some, but by and large, my impression was they're not on that career path.
Oh, right. So these are the firms that are using the levy to actually fund. Yeah, we've got 2 of those trainees in our law centre.
I think
We got 2 of them in our law centre.
is-
Yeah, we've got. Yeah, I sorry, I didn't understand the question, but yes, that's a great fund because the law firms in the city can actually pass that cash over from the levy for us to actually employ. We're employing 2 lawyers under that.
So
scheme.
city law firms aren't all bad.
I don't think anybody says they are,
No.
but this is precisely the sort of initiative that we should be talking about, but not just as, oh, this is a good example. It should be all about how do we scale that up? How do we make that work nationwide? Because it could be, if it's a good model, let's scale it up. There was a hand that went up ages ago in the middle. I don't know if, yes, the green cardigan. And I've seen lots of others go up since.
Hi, my name is Renee. I'm chair of the Association for Women Solicitors, and I'm also a practicing solicitor myself. Question here is how can regulation actively empower people? And just, I suppose, overlapping slightly with the earlier conversations, there's been a lot of talk about fighting back, priorities in relation to refresher training. From my personal experience, it's defendant inverted commas tactics that's quite off-putting to claimants particularly. I mean, we've got obviously so much in the media at the moment with the post office scandal. One of my colleagues running the Shell case where they're now withdrawing from their onshore subsidiaries in Nigeria after years of damage. I've had my previous role, catastrophically injured clients, amputees who have been, under surveillance, see how far they could walk despite the fact they've lost the lower limb. These types of ill practices tend to be commonplace and widely accepted. And then when we as claimant lawyers are trying to challenge that, we're essentially undermined by being called ambulance chasers or, lefty lawyers. Exactly. And I suppose that the question for you guys is really to actively empower. I personally think that we need to shine the light on these types of ill practices that have become commonly accepted. It's become the status quo.
I absolutely agree. I think that sort of chimes with points that were made earlier today about how all lawyers ought to be self-regulators. They should always be thinking themselves about are they doing the right thing, not just what they're being told to do or what's for the profits of the firm. There was a lot of agreement around that. And that people should call each other out as well. There was another point made just earlier about how should there be regular, possibly annual refresher training on ethics, which would remind all lawyers that what their duties are. There was a point that was made in the questioning from, I think it was from the online audience about, is it all right to do the wrong thing as long as everybody else is doing it? And that wasn't answered because everybody thought it was just almost a ridiculous question. Of course, it's not right to do it just because everybody else is doing it, but it's really common. And I think that's what we're seeing. And that's what exactly, some of the big problems have arisen because they haven't been called out earlier. Are there any questions from online that we should really be looking into that have come?
A few people have provided some good examples where things are working, maybe not just in the UK or outside of England and Wales, and we can share some of those around. There is some questions around, is funding the only solution? or is it, you know, to address high demand in legal services that's been recognised in the past and potentially in the future? And is funding just tackling the symptom rather than the root cause?
Oh, I don't mind giving my initial answer to that, and my panel members can then help me out. Without funding of some sort of funding for people who can't afford to pay anything for legal services, it's hard to tackle it, but it's definitely not the only answer. And it's not, you know, the fact that funding has gone down is not the only source of the problem. So I think it's a question of both and. I do think we can, things can be structured better. We could find a better way of, if you like, you're nationalising these initiatives that we've been hearing about, so that we can get some sort of proper cross-subsidy from the very rich parts of our sector. This sector is not short of money. It's sloshing around with money, and yet there are parts of the sector that we've heard about today that have got no money at all. So it's not the total amount of money that's wrong, it's where it's distributed. I'm being urged to go to questions, and there's somebody's pointing me to one in particular.
So we can take comments, but
no
we're going to
questions.
run out of time.
Okay.
So I
Comments,
leave
not
it to you.
questions, quick ones. Oh, there's a very keen one with a blue dress on.
Hi, my name is Amber. I'm not a solicitor. I'm a product designer slash a startup founder that is using design thinking to make immigration laws easier for migrants like me to access. And so I would like to make a comment as from a different perspective, as a product design student that built my education and career here, and which is, I think this country has an abundance of talents in various sectors, including design, where there are there are designs specializing in thinking for the future or thinking with user experience, and also abundance of entrepreneurs with innovations that are keen to explore. And I was wondering whether, I mean, okay, this should be a comment, but I think there is a great possibly a great chance to build collaborations cross industries, including actual designers that can actually grow grassroots into the people, consumers in need, and build and become a translator between between regulators and consumers, because legal language is like a foreign language to some.
Yeah, but you designers can help solve the. I agree with it. It's a good point. One last point. I think the one with the black something woolly thing.
Okay. So glad I got dressed up. Anyway.
Designer woolly thing.
Yeah. I'm Jane Robson. I'm the CEO of the National Association of Licensed Paralegals. So one of the areas that obviously has grown since the lack of legal aid and access to justice through the normal channels is that our paralegals have been sort of picking up the mantle in a lot of ways, and there's a lot more paralegal practitioners out there as well, and we hear this from our members. So my comment here would really be, I would like for you to engage with us voluntary regulatory bodies and professional organisations that do deal with the unregulated sector continue this, because I think we should be seen as a cohesive.
You're part of the solution. Absolutely. Thank you.
Thank you. Thank you very much for that all. We need to bring things to a close, because if I don't stop now, you're not going to have time to eat. And I'm guessing that will make me particularly unpopular. So I'm going to ask colleagues, please don't let anyone leave yet. Please join me in thanking Sarah and her panel. Now, Allan, lots of ideas there, which we need to come back to this afternoon on consumer-focused regulation, some tangible ideas on training, on more regulation, on more voluntary regulation, on more targeted regulation. So some thinking there for you, which we need to come back to. All Thank you so much for everything you have given to this morning.